The civil society organization, the World Institute for Peace, has accused the Osun State government of misleading the public over the administration of local government council and the release of allocation funds in the state. The executive director, Comrade Lamina Kamluddin Omotoyosi, at a press briefing on Friday in Osogbo, described the controversy as a product of an unlawful dissolution of the elected local government council in 2022 by Governor Ademola Adeleke.
Anything I say here today, I have every right, because this press statement is all about the development of our dear state, Osun. This is a press statement on local government allocation fund matters that has to do with our dear state. One, the World Institute for Peace considers it necessary to address the general public, the media, and all stakeholders on the lingering controversy surrounding the administration of local government councils and the release of statutory local government allocation funds in Osun State. Why we need to talk about this is because part of what we do is community service, and part of the community service is development of our society. And as we all know that among the three tiers of the government we have in this country, local government is the one that is very closer to the citizenry. This is why we also want to release our opinion. So this press statement is issued to clarify legal facts based on judicial pronouncements of competent courts, particularly the Court of Appeal and the Supreme Court of Nigeria, and to put an end to deliberate misinformation being circulated by the Osun State government and the People's Democratic Party, among other people who have been misleading the general public concerning this.
Lamina added that the Supreme Court later affirmed the judgment declaring local government a constitutionally recognized tier of government and ruling that funds allocated to council belongs exclusively to them.
So the decision of the Court of Appeal, majority judgment, it is majority decision as clearly stated in the certified true copy of February 25, that's the Court of Appeal. 1. Allowed the appeal of the APC chairmen in its entirety. 2. Set aside the earlier judgment of the lower court, because the Court of Appeal said the appeal is allowed. So declare the dissolution of the councils unlawful and unconstitutional. Order the immediate restatement of the APC local government chairmen and councillors. Affirmed that no state government has the constitutional authority to remove elected local government officials. Then the judgment remains valid, subsisting and binding. Then Supreme Court judgment and finality of the matter. The matter proceeded to the Supreme Court of Nigeria, which delivered its judgment through the majority of its justices. So the Supreme Court unequivocally held that local governments are a constitutionally recognized tier of government. State government and their agents have no capacity to dissolve, suspend, or control elected local government councils. Funds standing to the credit of local governments belong exclusively to the councils, not to state governments. Any interference with local government allocation violates the constitution. The apex court further affirmed that the local government chairman restated by the Court of Appeal in 2022 remained the lawful and legal occupant of the council because he has already dismissed the case filed by the ruling party. So this pronouncement by the Supreme Court represents the final position of the law from which there is no appeal.
The group warned the Osun State government to stay away from local government matters, focus on responsibilities constitutionally assigned to the state, and obey the judgment of the Supreme Court as required by law. From Osogbo, Temiloluwa Olubode, Inside Flix TV, Osogbo.